Hello students, your topic for today is incidents and disturbance under the property law and easement. The dominant owner may from time to time alter the mode of enjoying the easements. So the dominant owner can from time to time alter the enjoyment of easements, the mode of enjoyment of easements. However, by such alteration, he should not impose any additional burden on the servant heritage. He can he can alter it, but he cannot put any kind of additional burden on the servant heritage. Further, just for fun or pleasure, the dominant owner cannot alter the enjoyment of easement, though it does not impose any additional burden. Even if he is doing any kind of alteration which doesn't impose any kind of additional burden, but he is doing for fun or pleasure, then that is not allowed. He cannot do that. Fourth point, the dominant owner is entitled to do all acts necessary to secure the full enjoyment of easement. So he has all the right to secure his full enjoyment of easement. But he must do such acts without causing any inconvenience to the servant owner and without causing any damage to the servant heritage. This right of dominant owner is called accessory right. Fifth point, the expenses incurred in constructing works or making repairs for the use of preservation of easements must be borne by the dominant owner. So the dominant owner is liable for all the costings and expenses that occur. Sixth, in an easement which is enjoyed by means of artificial work, then the damage caused to the servant heritage must be compensated by the dominant owner. So if the easement enjoyment is of artificial work, then any kind of damage that occurs on the servant heritage, for that the dominant owner is responsible to compensate. Seventh point, the servant owner need not to do anything for the benefit of dominant heritage, and he can use the servant heritage in any matter but without affecting the enjoyment of the easement. So the servant owner has the right to enjoy his servant heritage in whatever way he wants, but he should make sure that whatever way he's enjoying, he is not affecting the enjoyment of easement to the dominant owner. So need not do anything for the benefit of dominant heritage, but to make sure that uh, whatever way he is using to enjoy his servant heritage, he is not affecting the enjoyment of easement. It will not create any kind of interruption or hindrance in the enjoyment of easement. Eighth point, in deciding the extent of easement and modes of its enjoyment, the intention of the parties and the purpose of which the easement was acquired must be considered. So, purpose and intention of the parties is to be considered to understand how much should be the easement right be extended to and what mode of its enjoyment should be. In the absence of evidence for intention and purpose, the following are the rules. So if in case there is absence of evidence for the intention and purpose, then these two rules apply. First, in case of right of way, one kind does not include the right of any other kind. Second, in case of right to light or air acquired by grants, the quantity of light or air available during the whole of prescription period is considered. Ninth point. Easement can be increased by alluvion, and diminished by diluvion, and it cannot be increased by mere altering or adding to the dominant heritage, and for that matter, easement is not at all affected by any change in the dominant or servant heritage. Tenth point. When a dominant heritage is divided between two or more persons, the easement becomes annexed to each of the shares. So if the dominant heritage is divided, then the easement will also be annexed to each of the shares. Example of this is a house is divided into two parts and given to two persons. Each is entitled for the right of way. 11th point. In case of excessive use of an easement, the servant owner may obstruct the user on the servant heritage only. Further, such obstruction should not affect the lawful enjoyment of easement. Suit for disturbance of easement. Now, disturbance of easement. The owner of any interest in the dominant heritage or the occupier of such heritage may institute a suit for compensation for disturbance of the easement or of any right accessory thereto, provided that the disturbance has actually caused substantial damage to the plaintiff. So, in this case, one can the owner of the dominant heritage or the occupier of such heritage can institute a suit for compensation. But the main point is this, that the disturbance that is being created should create a substantial damage to the plaintiff. Explanation 1. The doing of any act likely to injure the plaintiff by affecting the evidence of the easement or by materially diminishing the value of the dominant heritage is a substantial damage within the meaning of section 34. So, if any act which will likely to injure plaintiff by uh, by diminishing the value of the dominant heritage will be considered a substantial damage. Second, where the easement disturbed in right to free passage of light passing through the openings in a house, no damage is substantial within the meaning of the section, unless it falls within the first explanation or interferes materially with the physical comfort of the plaintiff. So, if in case there is a disturbance due to there is a disturbance of right of free passage of light for passing through the opening in a house, then that will not be considered as a substantial damage if within the meaning of the section. If in case it falls under explanation 1, then it is a different case, then it will be considered. Or if it interferes materially with the physical comfort of the plaintiff, then it will be considered as a disturbance. Or if it prevents him carrying on his accustomed business in the dominant heritage as beneficially as he had done previous to instituting the suit. So if it is affecting his carrying of the accustomed business, then it will be considered. Explanation 3. Where the easement disturbed is a right to free passage of air. So the explanation 2 was regarding light. Now explanation 3 is regarding passage of air to the opening in a house. Damage is substantial within the meaning of this section. So in this case, it will be substantial. And if it interferes materially with the physical comfort of the plaintiff, though it is not injurious to his health. So where the easement disturbed is a right to free passage of air to the opening in a house, damage is substantial within the meaning of the section if the main point is if it interferes with the physical comfort of the plaintiff. If passing of the air is creating disturbance and the passage of air is there is disturbance in that, and due to which there is a physical discomfort that is happening to the plaintiff, and though it is not necessary that it should be injurious to his health, but it should be a discomfort, then in that case it will be considered as a substantial damage. Illustrations. First example is A places a permanent obstruction in part over which B, as tenant of C's house, has a right to weigh. So there is a house uh, whose owner is C, and in that house B is the tenant, and B has a right to weigh on a path. On that path, A is placing a permanent obstruction. So this is a substantial damage to C, for it may affect the evidence of his reversionary right to easement. B. A, as owner of a house, has a right to walk along on one side of B's house. So A, who is the owner of the house, he has a right to walk along at one side of the B's house. B builds a veranda overhanging the way about 10 feet from the ground, and so as not to occasion any inconvenience to foot passengers using the way. This is not a substantial damage to A. Thank you.